those of you who know me, I do love a long lunch. So if you can organise that for me with Alex Baldwin, I'd be delighted. So I'm an accident and injury lawyer, or in the field I'm actually known as a personal injury lawyer, and I operate under tort law, and a little bit of contract law as well. So the word tort comes from the French wrongful act, and the reason it was introduced was to provide a legal system of redress for a person who has suffered a wrong, so they didn't take their own private revenge. So it was to bring civility to society. The parties involved are the plaintiff, the injured person, that's my client, and the defendant, the person who caused the injury. And there can be one defendant or a number of defendants. Now, tort law seeks to pay compensation for a wrongful act that results in injury to another person's reputation, so you have defamation. It can be to property, trespass. It can be for giving negligent professional advice, so it results in economic loss as opposed to injury. And my area, my specific area within tort law is personal injury and negligence. Now, some of you probably think this whole tort law, we've become a compost society, it's only a new area of law. How many people here think that tort law is a relatively new area? Can I have a show of hands? Yeah? Well, it's been around since Roman times in some form or another. And if we look at this quote from an English judge, I'm not going to go through it fully, but what he's actually saying, if you're doing an action, such as driving on the road, you have a duty to do it in a way that won't cause harm to somebody else. And you could actually put that quote, let's see if I can use that, you could put that quote into a judgment today, and imagine it's from 1146, and it wouldn't look out of place. So tort law has been around a long, long time. So as Lucy said, my clients do injure themselves in a variety of ways, and typically my clients are people who've suffered injury in transport accidents, so your usual cars, motorbikes, etc. Injuries at work, sexual assault, I've done a number of sexual assault cases, physical assault, often by bouncers. I've done a lot of cases where bouncers have seriously injured people. Cases against the police for unlawful arrest or unlawful imprisonment. I've put in about dog attacks because I love dogs, but if you own a dog, it's strict liability. If your dog attacks somebody, you will be found liable. It's not really a question of negligence. Other cases I do are the injuries in the community. So your trips, slips and falls, they happen in your private home. There's just recently been a case where a private homeowner was found responsible for an injury where somebody slipped on a very slippery floor. Shopping centres, car parks, generally in public places. I've put in about balconies collapsing. I've done loads of cases about balconies collapsing. So if you're at a party, never lean against the balcony railing, is my advice. And of course the other area I do is medical treatment, negligent medical treatment and advice. Now the fact that you get a bad outcome from treatment doesn't mean it's negligent. And that's my job as a lawyer, to see if in fact it is negligent. So is the only thing you need an injury? Well, the answer is no. I'd probably be really rich if that's all you needed. Some people ring me up and say, I suffered an injury, but it's because of their own fault. They fell over their own feet. There's no claim. I have to prove negligence. The only area that's a little bit different is where you have a work injury. I just have to show the connection with work. I do not have to show the employer is negligent. I am simplifying this a little bit, but these are the general rules. So when somebody comes to me, the first thing I have to look at is whether there is fault, there is liability. Sometimes it's easy. So fault is made up of different components, and in layman terms we talk about, and if you looked at the judgment you'd see all of these issues talked about. Was the plaintiff owed a duty of care? Generally that's easy. You've got a doctor, patient, road users. Sometimes though it's not as straightforward, and the courts will say, no, that's too remote. The distance between, or the relationship between the person who suffered the injury and the person injured is too remote. We're not going to find that it's negligent. Was there a breach of duty? Was there negligence? Sometimes easy. Somebody runs a red light, very straightforward. But often it's not straightforward. So trips and falls, they are not straightforward cases. They're very hard cases to win. Medical negligence cases are very difficult to prove fault. And I think that's how it should be. You know, it should be difficult to prove that somebody is negligent. The other issue that comes up in cases nearly all the time is whether the actual injury has caused the loss, because often people have other things going on. They might have a pre-existing back injury, for example, and there'll be a big argument. And a number of my cases, I'll have those arguments that there's something else that's causing their inability to work. It's not the injury. So just moving ahead. So when you hear of judgments, sometimes on the radio you'll hear a judge awarded X amount of dollars today. So whether they award 30,000 or 30 million, it'll be made up of different sections. So when people come to me, sometimes there'll be negligence, but the injury is too little to be commercially viable to bring a claim. And that's particularly if it's going to be a hard fight on liability. There's no point bringing a claim that's worth, 10,000, because you'd use it up in legal costs. But the normal heads of damage are pain and suffering, treatment expenses, personal care, and loss of wages. So all of those, you're trying to get the evidence to connect those losses with the injury caused by the negligence. If somebody's had a catastrophic injury, so I'm talking about, say, a paraplegic, there's additional home and motor vehicle modification claims, increased holiday costs. If you're in a wheelchair, you're probably going to have to travel business class, you're probably going to have a carer with you. The other area is fund management costs. So if you've suffered a brain injury, you probably lack the capacity to manage your own funds. So we have to claim for a trustee's cost, and that's often actually usually hundreds of thousands of dollars. So why do you need a lawyer? Some people try and do these cases on their own. So Ursula was telling us today about he met somebody trying to do a case on their own. It's really fraught with danger because they give the wrong information to the insurance company. They give information that works against them. So it's a complex area of law. Insurance companies, and I have said this before, they have deep pockets and they have a lot of experience. And I've definitely seen cases where they will try to settle a claim under value if there's no lawyer involved. And they get away with it. That's why they do it. The other thing is, though, if they can't settle, they have deep pockets, they'll spend lots of money on getting top lawyers involved and other experts to defeat a claim, or at least to substantially reduce the value of a claim. So I've seen claims where insurers have offered 70,000 when it was worth 500,000. And they get if somebody hasn't got a lawyer, they have no idea, and they'll accept that 70,000 sometimes. And the other thing, and I think even more importantly, you only get one chance to run a claim. You can't run it and then say, "Oh, Your Honour, thanks for that experience, can I have another go?" You're just not allowed. And the High Court has said to us, a plaintiff cannot complain about inadequate damages or inadequate compensation if they haven't given us the evidence. So a lawyer, a personal injury lawyer, look for somebody who's an accredited specialist, works in the area all the time. They'll know what evidence to get. They'll know how to put the evidence before the court. They'll know to advise you whether you should settle the claim and run or whether you should fight the case and go forward. And they'll know the rules. There's a lot of rules that can cause technically defeat. People always worry about costs with lawyers. As a personal injury lawyer, I work on a conditional cost agreement. If you don't win, you don't pay. Also, insurance companies have to pay 65 to 75% of the legal costs in any event. And finally, ideal referral for me, somebody who's suffered a catastrophic injury, but also lesser injuries, back injuries, whiplash, psychological injuries. Other very good contacts for me, the medical profession, other lawyers. I actually get a lot of work from other lawyers, and embassies, because if you're a foreigner and you're injured in Australia, your embassy will be contacted. And that's it from me. Thank you.